We now present For the Record.
Welcome to For the Record from the Wisconsin State Capitol. I'm Will Keneally. We start this morning with news breaking late this past week. The Wisconsin Supreme Court has struck down the state's legislative districts, banking a significant win for the Democrats, who are hoping new legislative maps could create more competitive races in the state legislature. We sat down with UW law professor Robert Yablon in the wake of the decision. Here's more from our conversation. So any initial reaction to how this decision shook out?
Well, this is a big decision that folks have been waiting for. It came out today at 250 plus pages of opinions, a majority opinion and 3 separate dissents. And the bottom line, which I think a lot of folks had been waiting for, is that the opinion says that Wisconsin is going to need new state legislative maps for 2024. In terms of the remedy, one thing that is worth noting is that the Wisconsin Supreme Court said that when the court draws new maps and when parties submit new maps, it wants to consider partisan fairness. The court is concerned, even though this isn't a partisan gerrymandering case, that Wisconsin's electoral maps have been significantly skewed for more than a decade. And the court said in today's opinion that as a court, it is supposed to be an impartial, neutral body. And so it wants to ensure that whatever map it ends up adopting does not have the same sort of partisan skew that we have seen in Wisconsin's past map.
If they don't, do anything timely enough to get these maps in place by 2024, then the court will step in and appoint someone to help them draw the maps. Have we seen that before in other redistricting cases?
Yes. So what the court said is that redistricting is first and foremost the legislature's responsibility. And so it's reminding the legislature that it still has an opportunity, if it can reach agreement with the governor, to enact new maps. And the court says, we would like you to take this out of our hands and do redistricting in the way that the Wisconsin Constitution contemplates. But I think the court recognizes that there's a decent chance that the political branches will deadlock again, as they did a couple of years ago. And so what the rulings today say is that we're going to begin a process for the court to create maps. That process will involve the litigants in the case being able to submit proposed maps. And then the court has appointed 2 expert consultants that are going to help it evaluate the maps that are submitted. And the consultants are supposed to work with the litigants on the various criteria, the data that they want them to use. And then we're going to get some reports and some briefing on that. And so that's going to play out in January with the creation of and submission of initial new maps. And then the experts are slated to provide their report to the court in early February.
So it was a 4-3 decision with, as you would expect, the 4 liberal justices all siding with each other, the 3 conservative justices siding with each other. Was there anything interesting from the multiple dissents from this decision here?
I mean, one thing that is somewhat notable about the dissents is that there's only a limited extent to which they take issue with the majority's ruling on the merits, right? This case is not actually a case about partisan gerrymandering. We've kind of thought about our redistricting issues in Wisconsin in those terms, but the legal issue in this case is an issue about the contiguity of the state's electoral districts. And we have this very funny and unusual thing in Wisconsin where more than half of our state assembly districts, almost 2/3 of the state senate districts, they aren't geographically contiguous, meaning that you have different pieces of territory that don't touch each other, but they're put together in one district. And our state constitution says that districts should be comprised of contiguous territory. And the early practice in our state was we did exactly that. In recent decades, we've allowed these discontinuous pieces of territory. It hasn't really been challenged in a serious way. Now it is. And the majority explains why that's not consistent with the Constitution. There's not much pushback on that point in the dissents. In fact, one of the dissenters, Justice Hagedorn, says that he agrees that if you think about the original meaning of the Wisconsin Constitution, it probably does require these contiguous districts. So instead, what the dissents mostly focus on are essentially some procedural grievances. And some of these get fairly technical, but big picture, what the dissenters are arguing is that they think that this all was resolved 2 years ago in the Johnson litigation in 2021. That's when the Wisconsin Supreme Court adopted new maps after the 2020 census. And their view is that all of these sorts of issues about contiguity accessibility or other things should have been and were resolved in that case, and that it's not appropriate 2 years later to go back and create new maps.
Wonderful. Professor Robert Yablon, thanks so much for joining us. Really appreciate it.
Yeah, great talking to you.